Hey, it's James, Father's Rights and Resources, hashtag how I got custody. Over my shoulder is a page called the 28th on the 28th, or a group of people doing a march in Washington, D.C., and they're proposing a 28th Amendment with parental rights that are supposed to fix things. But I called these guys, they asked for input. I called them on Monday, left a message. I didn't hear anything back from them. They probably don't care, but I want to point out how this is yet another wasted. Fathers' rights groups have been doing stuff like this and asking for 50-50 laws and stuff for 40, 50, 60 years and getting nowhere on it. And even the 50-50 laws in some states, those presumptions, they don't help cases where women are lying about domestic violence and child abuse, because they win when they lie without the presumption of 50-50, and they win when the claims of allegations of abuse wipe out any presumption of 50-50. So let's take a look at the language, and let me show you why these people aren't even thinking about what they're talking about. This is where guys get emotional and say, oh, this sounds good. The problem is, here's the root of the problem. You serve it up for the judge to decide what's true and what's not true, and if the judge is biased, they'll just rubber stamp whatever the mother says. This doesn't fix anything of that. It doesn't fix the root of the problem. And idiot after idiot keeps coming to legislative action and stuff like this, and they write things up in a way that doesn't help at all. Let me show you. Okay, this is amendment28campaign.org. That's the website. So let's take a look at what they're trying to propose. They say, we're excited to announce the 28th on the 28th Father's Rally on Parental Rights has been scheduled despite our delay. Mark your calendars. Okay, see you there. Advocating for the passage of the 28th. The proposal seeks to enshrine parental rights as a fundamental constitutional guarantee. It's already guaranteed in the Constitution. They never heard of Troxel versus Granville? The amendment would establish the right of parents to have equal and meaningful involvement in the upbringing of the children. Would establish the right of parents. A determination on the time is up to the judge, and as long as it's up to the judge without any mandatory requirements, it's up to the judge whether you get 1 hour of visits or whether you get 50-50 or full custody. Both parents, regardless of gender, equal time, all that stuff. It aims to promote joint custody as the standard in family law. It's already the standard, because the best interest of the child is the standard, and if lawyers would argue it correctly, we would have that as the standard. Safeguarding the rights of fathers and mothers alike, providing clear protections against arbitrary and unequal treatment. This is not going to protect that. Let me show you when I get to their language. The amendment emphasizes the importance of maintaining strong parent-bond relationships. The laws already say that. These idiots aren't doing anything. And see what they say is it's all emotional. We are excited to announce this, and we want to have parental rights. This proposal seeks to enshrine parental rights as a fundamental. It's just emotional. There's no logic to this stuff. Let me pause and get to the page that has the language. Okay, so they say we aim to draw national attention to the unconstitutionality of family courts. It's not unconstitutional. Well, it's unconstitutional if they interfere with your rights without due process. See, I don't know who's the idiots who are doing this. They probably got a bunch of numbnuts up in here, and no lawyers or idiot lawyers. In the United States, by demonstrating fatherly love and national law, our efforts include creating groups to lobby key influencers. Oh my God! So who's the key influencers? If there's key influencers in there, how come they haven't done anything already? Through impactful speeches, we will highlight the tragic consequences of current family court rulings. They've been doing this for 60 years. These guys are acting like they're saying something new. Let me propose the amendment. Here we go. I wasn't on this page. The fundamental rights of parents to ensure the fundamental rights of parents. It's already in Troxel versus Granville. The problem is, like I said, judges don't apply it right. How are you going to say, oh, we really want fundamental rights, and you expect judges who ignore those fundamental rights to stop ignoring them? They're going to start following what? Oh, here's their thing. Joint custody presumption. In any custody determination involving minor children, it'll be presumed that 50-50 is the best interest of the child. Shall be the land unless clear and convincing evidence demonstrates otherwise. So you know what a judge has to do? All a mother has to say is, hey, I'm scared of him. And they say, this is clear and convincing evidence to me. If these idiots want to change anything, they should have a law that says 50-50 unless there's a criminal conviction of child abuse or domestic violence. A conviction. This clear and convincing evidence, you know what that is? It's somewhere in the middle between preponderance and beyond a reasonable doubt. But even if they said beyond a reasonable doubt, it's still up to one judge. And the judges are bigoted toward fathers. And it doesn't matter whether you have preponderance evidence, clear and convincing evidence, or beyond a reasonable doubt. The judge can just say, beyond a reasonable doubt, I believe the mother. This is gonna make mothers want to make more false allegations because they will get 50-50 unless there's evidence that demonstrates otherwise. And she says, oh, he's a monster, he's abusive, he was neglectful. And then he says, no, I wasn't. And then the judge decides, based upon clear and convincing evidence, whether or not the father should still have 50-50. The only time this will work is when a mother doesn't really want to fight that hard. But that makes it in kind of an uncontested case. Of course, she'll strive to ensure equal parenting time between both parents. The laws already say that everywhere. Look at California Family Code 3020B. There's a Washington RCW 2609002 says the best interest of the child is normally served when the existing pattern of interaction continues. If you were married, the existing pattern was 100% of the time. How come they're giving people every other weekend? This will not fix the heart of a judge. These guys are such stupid jackasses. It's ridiculous. And I reached out to them to try and tell them, look, the judge has absolute discretion, and there's no bounds except you have to do 50. Think about this again. You have to do 50-50 unless there's clear and convincing evidence that demonstrates otherwise. And again, all they have to do is say the words, I declare by clear and convincing evidence that the mother's the better custodial parent. And they rubber stamp it. Bam. I can't believe these grown-ups are this stupid. This is why, people get mad at me for being mad. This is stupid. This is stuff that doesn't work and hasn't worked. In states where they got 50-50, there's still people getting every other weekend or less than that because they still accuse fathers of abuse. And that trumps it. Let me tell you this. In Missouri, they actually have a 50-50 proposed schedule, and it says there's a presumption of 50-50 unless the court finds it's not in the best interest of the child to have 50-50. So they don't even have clear, cogent, and convincing evidence to the contrary, or if there's abuse or neglect or whatever. It's if the judge thinks that it is in the best interest. So you're right back to the judge saying whatever's in the best interest of the child. And if you have a bigoted, that's like saying in the Jim Crow South, black people have a right to due process on paper. And you shouldn't discriminate against them. And you should assume that they're innocent until proven guilty. And they're innocent until they're proven guilty beyond a reasonable doubt. That's already in the law. That's like if what I just said, if I came up with that and put it in like different wordings or different one document, that's already in the law. Black people were getting mistreated in Jim Crow South because white people hated black people or they were bigoted against them. These judges are bigoted against fathers. And so even though the laws say an alienating parent, an emotionally abusive parent, a mentally ill parent, a parent who withholds a child for no good cause, which parent is willing to facilitate a relationship with the other parent, all those things are already in the law, and the judges totally ignore them. What makes these stupid jackasses, these brainless numbnuts idiots, it's probably some father's rights movement numbnuts who never won in court and are drafting this stuff up, and they're all excited because they're going to have a speech at Washington, D.C., and a group of disenfranchised fathers getting together and talking to each other about how bad they got screwed isn't going to influence the people, the judges, even if you have laws that say presume 50-50, the judges still have the final say. How do people not get this? So then they say the judges should not discriminate. Oh, that's going to stop them. Say don't discriminate. And then because it says this on a piece of paper somewhere, the judges aren't going to do it. My God. These people, they have all this power, money, and time to be able to assemble all these people to come up with a stupid idea again and do something that's not going to accomplish anything. Oh, let's have fair trials too. They're going to be fair just because these people say so. My God, my gender is so freaking pathetic. It's ridiculous. These guys are idiots.